Good afternoon, everyone. You're welcome to today's webinar. My name is Iretioluwa Banjo, and I'm the session coordinator. So we're here to discuss a very crucial topic, which is appointed and being appointed as an arbitrator, rules, realities, and the road between. Like you know, this webinar is organized by the Corporate and In-House Counsel Committee of the Chartered Institute of Nigeria, Arbitrators Nigeria branch. The aim of this webinar is to demystify the process of arbitrator appointment, to know how arbitrators are selected, and how you can transition into an arbitrator. There is a quote I really find interesting. It says, "It's the well-settled fact in law that parties take their arbitrators for better or worse, both as a decision of fact and decision of law." So it means once you have chosen an arbitrator, whether or not the arbitrator is experienced or knowledgeable about the subject matter, you've entrusted your faith into them for good or bad. So it just looks like you go to the hospital or you take someone sick to the hospital, the person needs to have a surgery, and they tell you, oh, the doctor is a rookie, has just left med school, or a dentist wants to do an appointment. So you're thinking, is this doctor the best fit to carry out this surgery? That's how arbitrators are. So the choice of arbitrator is very crucial. And if you're wondering what your next role would be after your in-house role, this is a career path you should strongly consider. So before we delve in, just a few housekeeping rules. All the microphones will be muted throughout the webinar, but you can start dropping your questions in the chat. We will see it and your questions will be treated. And please, you don't need to introduce yourself in the chat room because we'll drop the link for the CPD during the meeting. And note you can drop your questions in the chat room. Yes, moving straight into the webinar, we have three renowned speakers with us here, and I'll be reading their profiles. We have Professor Wale Olawoyin. He has practiced law for over 3 decades and a half, and he's been teaching law for about 27 years in the Faculty of Law, University of Lagos. He taught me. He sits on the board of director of a number of companies and is currently the chairman of Page International Financial Services Limited, Lagos. He has acted as arbitrator in a number of international commercial arbitrations, and he was elevated to the rank of Senior Advocate of Nigeria in 2014. He is also a fellow of the Chartered Institute of Arbitrators UK and Institute of Construction Industry Arbitrators. He's currently the president of the Lagos Court of Arbitration. You're welcome, sir. Our next speaker is Manish Aggarwal. I hope I pronounced this well. I had to go to Google to look for the pronunciation. He's a partner in the London office of Three Crowns, and he has extensive experience of representing clients in commercial and investment treaty arbitrations across a broad range of sectors, including energy, power, infrastructure, life sciences, telecommunications and technology, and in arbitration-related court litigation. He also has experience as a moderator, including in cases held under International Chamber of Commerce and Singapore International Arbitration Center rules. He is consistently ranked as a leading practitioner in arbitration and international law by major legal directories. You're welcome, Manish Aggarwal. Thank you. Our next speaker is Mr. Gbenga Bello. He has dedicated himself to diverse areas of practice of law for about 25 years in a career that cuts across trial, advocacy, commercial and regulatory advisory, and strategic thinking for in-house counsel. He's currently an associate director in IHS Tower, Nigeria, where he oversees the entire dispute resolution unit of the legal department, devising strategies for settling complex disputes. He was opportune to start his career with some of the best law firms, which exposed him to courtroom advocacy. And prior to joining IHS, he had a stint with the Nigerian Stock Exchange. You are welcome, Mr. Bello. Yes, you can see we have a good lineup of both arbitration practitioners and in-house counsel with experience in arbitration. We're going in shortly. I know you can't wait to hear our speakers. This beautiful session will be moderated by our own Mrs. Oyinlola Adebayo. Mrs. Oyinlola Adebayo is Company Secretary of Asset Management Corporation of Nigeria. She holds an LLM from Osgood Law School, York University. She's a fellow of the Institute of Chartered Secretaries and a chartered arbitrator with the Institute of Chartered Arbitrators of Nigeria, UK branch. She has developed expertise in law, administration, and resource management, particularly in documentation and record keeping. Some of her core competencies include risk management, contract negotiation, contract drafting, litigation, legal issues, legal support, regulatory compliance, legal process, and intellectual property rights. Wow, what a CV. Thank you very much, Ma. So now over to you to take us through this presentation and the beautiful discussion we're about to have.
Good morning, everybody, and I want to welcome our panelists from all over the world that are joining in, from Professor Olawoyin to Manish Aggarwal and Mr. Gbenga Bello. You are all welcome, and we'll dive right into this panel discussion. We have so many questions for you, and we also want to have a little bit of time to have questions from the audience. One of the things I'm going to quickly note is that we're going to have a few minutes, about 20 minutes for the audience to take your questions. What I would ask you to do, that all questions should please be put in the chat room. Kindly state your name and probably where you work and where you're calling from. That would allow us to sieve out some questions to take and give to our panelists. So without much ado, we are going to go into some of these things, and I hope you are all listening attentively and have your pens and papers ready. So the first question we all obviously have is a general question. So by way of introduction, we'll be moving from general to specific questions. So the first one I will start with is a general question for everyone on the panel. And it is, what led to your foray in arbitration? If you can briefly take us through your journey or transition. And I will start first of all with Professor Olawoyin.
Good afternoon, everybody, and thank you, Oyin, for your introductory remarks. And let me also thank the Chartered Institute for giving us this opportunity to speak to some of the issues around appointment of arbitrators. Well, my own foray into arbitration is quite interesting. In the late 80s, I went to the UK to study for my master's. And I met a Cameroonian chap. We were both in LSE. And I mean, the subjects that he chose were just essentially arbitration subjects. And this was just a year after the ACA was passed in Nigeria. So it wasn't an area that I was particularly interested in. I thought that it was one of these areas, that we generally characterize as soft law. But over the course of the 1 year, with the Cameroonian chap, who incidentally is now the president of Afreximbank, I then developed an interest in arbitration. By the time I came back to Nigeria, and all of us know with the difficulties around litigation of disputes, the time spent, and then the whole idea that you could decide who was going to adjudicate on your dispute. You then had the choice of choosing specialists with expertise in the area, rather than just a random situation that you have in the courts, that a very complex matter on a specific subject matter is given to a judge who might have no knowledge about that area, and it's not meant to be condescending to the judges. So it was on that basis that I sort of developed an interest. And my first appointment came in 2008. At that point in time, I had not even done any training in arbitration, so to speak. And when I look back at that award, I tend to cringe, because I wrote the award like I was writing a judgment of the court. And thank God that there was no attempt to challenge that award. It was in respect of a casino in Victoria Island in 2008. And then between 2008 and 2016, when I really started my career as an arbitrator rather than a counsel. It was all a function of attending conferences, getting the knowledge in the area, both in a domestic context and international context, which will be some of the things that we'll talk about later in terms of preparing yourself to be an arbitrator in this context. So thank you very much. You're muted, Onilola.
Oh, I am. I have to learn the ropes of this thing quite well. Thank you so much, Prof, for that brief introduction. I will go over to Manish. Can we quickly have your perspective as well?
Thanks so much, and it's a real pleasure to join all of you. I'm dual qualified as an Indian advocate and an English solicitor, and my journey in arbitration started with law school in India, where I first encountered arbitration through the Wismoot in the second year of law school. Then in my penultimate year in law school, I had an opportunity to study at a University of New South Wales in Sydney, where I studied international investment arbitration law. I think it is those experiences that really shaped my direction. Now, I should note that this is 2007, 2008, and at the time, the opportunities to practice arbitration in India were limited. So I decided to pursue a career overseas. And my first professional home was London. I worked with a magic circle firm called Allen and Overy in London and Singapore for 6 years. And then I joined my current firm, Three Crowns, which is a specialist international arbitration firm in 2014 when the firm was launched. And I became a partner 4 years later. And in terms of my practice, that is primarily focused on counsel work in both commercial and investor state arbitrations, where we act for both states and investors. But I also sit regularly as an arbitrator. So I think in terms of kind of my journey, it's really been driven by my international exposure. I've lived or worked in India, Australia, Singapore, and now UK for the last 17 years. And that's been quite integral to my learnings, as well as my approach to my work, both as counsel and arbitrator. I'll pause there.
Thank you so much. We're still waiting for Mr. Bello to join us, but in the meantime, I want to appreciate our speakers for that brief background.
I think he has
So
joined.
you are in. Oh, thank goodness. So, okay, Mr. Bello, can you quickly give us your perspective? And I'll just repeat the question quickly. What led to your foray into arbitration, and briefly take us through your journey and or the transition?
Well, my journey into arbitration was one I'll consider as deliberate. There was no arbitration in the curriculum when I was in law school, and by the time I had, become a lawyer, the first law firm where I worked had 3 of the partners were members of the Chartered Institute, and and at that time it was a fledgling thing in Nigeria. And what interested me was the fact that, being a litigator, there are situations that require some other model. And this model was particular. I thought litigation was everything to law at the time. And as a young practitioner, reading arbitration myself was quite interesting. I didn't know there was such a thing that would give parties the choice and the freedom to come to an agreement on how to have their dispute settled, and that was the interesting thing for me. And by the time I was doing about 3 or 4 years in the firm. I was already a secretary to a panel in the firm, that carried out an arbitration at that time. And, up until now, I've not had a formal training on arbitration, but my learnings come from participation in arbitral panels, either as secretary or counsel. And up until now, it still forms a remarkable moment in my career towards where I am today.
Thank you very much for that. I'm really happy we actually took this question because it's given, I believe, our audience a good background to know that you can really come from various places and your origins can be as diverse as our practices are, and you can all end up in this same spot. So thank you for sharing that with us. So my first specific question goes to Manish. How does one continue to position oneself for appointments now that you are in this industry and you've given us this background? What do you do to position oneself? What can we learn?
Thanks so much, Oinola. And that's a great question. And I think the best place to start is by actually flipping that question.
Okay.
And ask the question as counsel, when you're appointing an arbitrator, what are you really looking for? And I think in a nutshell, what one is looking for is a safe pair of hands, someone who's strong on substance, can run the process efficiently, and can deliver a final award in a reasonable time frame. So positioning oneself for appointments really means demonstrating that you can do those things and can be trusted to do them. I would note that in most cases, the first appointments are likely to come from arbitral institutions rather than from the parties. And I would then share with the group, the three principles, which have been highlighted to me over the years, and which I think are quite key if one is looking to position oneself as an arbitrator. And in a nutshell, the way I would put it is, be in the know, be known, and serve. Picking up on what Benga said. First, be in the know, and what does that mean? It really means understanding how arbitral institutions make appointments, and making sure that the institutions know that you are available for arbitral appointments. And that might mean submitting your arbitrator CV, getting on the arbitral institutions panels, filling out your guard profile, and letting counsel in the community know that you're open to appointments. The second point I would emphasize is what I described as be known. And that is really about building your brand and visibility. And that can be achieved through a number of ways, right? You can speak at events, you can write and teach and contribute to various academic committees. Again, a chartered institute obviously provides a platform for that. And increasingly, strategic use of LinkedIn has also become quite important, right? And all of that is really to showcase that you are a thoughtful arbitration practitioner, you're technically sound, somebody who has gravitas. One thing I would add, and that is something that we've all learned over the years, is one has to be quite careful in our field about not over trading, because and often and I hope this wouldn't happen at this event, but we've all been at events where you have speakers who don't come prepared, or not kind of don't really kind of showcase their skills, and that can affect how your credibility may be affected. So yes, it's quite important to build your brand and establish yourself as somebody with gravitas, but you have to obviously put in substantive preparation into that and have to be thoughtful. And I'll conclude by just noting the third principle, which is serving. And again, this was picked up by other panelists. One experience that I found particularly useful is serving as a tribunal secretary. It can provide a valuable stepping stone It can give you direct exposure to top-tier arbitrators. And it also gives you, real practical insights on matters involving case management that you don't often find in textbooks. So I think those are kind of my thoughts on how one can position oneself to secure arbitral appointments.
Thank you very much for that, Manish. So from what I get, at least personally for me, it's actually quite intentional. The effort has to be quite intentional. It's not just going to come to you or land on your lap or just by signing up. One key thing I really picked out is the overtraining. We do like the numbers and the letters beside our names, but there has to be a lot of confidence and competence that come with it. Thank you so much for that insight. It's a similar question to Professor Olawoyin. If you can just give us a quick 1 minute, what advice would you offer to those who are seeking to be appointed as arbitrators from your experience?
Thank you very much, Oyinlola. And I must thank Manish for sort of covering the field broadly in terms of what you need to do as an aspiring arbitrator in terms of being in the know and building the brand. But I just want to focus on building the brand, and the way that I put it to young arbitrators that I mentor is the visibility point. The visibility in terms of being around conferences and stuff like that. I was at a meeting last week, the ICC arbitration and ADR meeting, and Mrs. Uford made an interesting comment, which I now call PTP. She says, pay to play. You have to spend money a bit in terms of traveling around and being visible at all these conferences and making important interventions at this respective fora. Another particularly sort of easier way of also easing yourself into the consciousness of people is by writing. But writing is a double-edged sword. There are things that I see out there that are not of substance, are quite pedestrian. So you don't want to get a reputation for writing pedestrian stuff just because you want to be seen to be writing. And I say to my junior colleagues that there is a lot of room, particularly in the Nigerian environment, of demonstrating that you have a deep knowledge of the area. And we have so many platforms locally for you to exhibit your knowledge in this area. We have the CIAB journal. We also have the LCA journal in Nigeria. These are platforms, and then there's the newsletter as well. So these are platforms for you to engage in writing in areas, and as much as possible, don't be a master, or don't try to be a master of all. I see young colleagues today, they write about maritime law. Tomorrow they are writing about intellectual property, and then you wonder and say to yourself, look, you can't really be interrogating the issues as effectively as you ought to. So my suggestion is to the young people is that apart from some specific subject areas that you can sort of focus on, there are areas of general arbitration law and practice that you can focus on. And then, as I said to some other younger people, if you want to step it up a bit, one critical area that I've noticed, whether it's international commercial arbitration or domestic commercial arbitration, is a solid, thorough grounding in the law of contract, particularly in the area of damages. So if you start writing in those areas, potentially you will come to the consciousness of people when they have all these complex cases, when they just, I read something from this chap a while back and it's quite relevant to what we're trying to do. Who's this chap? Let's look for this chap. So those are the kind of things that you can do in terms of putting yourself in the consciousness of people. I, as an appointer in the Lagos Court of Arbitration, these are the kind of things that I look at in the context of young arbitrators. I would say that in my 4 or 5 years as the president of the LCA, 95% of my appointments have been young arbitrators because of, one, the nature of the disputes that we have. They're not big ticket disputes, you know. So I thought that, look, this is a good opportunity for me to get the younger ones to cut their teeth in terms of writing awards and stuff like that. So I always encourage. And before I appoint you, I have to look out and investigate you, you know. So these are the things that I look at when making those appointments as president of LC. I think I'll pause there.
Thank you so much, sir. That's so insightful. I've been taking notes anyway, so I'm pretty sure our audience have been doing the same thing. One thing I didn't notice that you mentioned quite elaborately, along with Manish, was the issue of mentorship, and I'm pretty sure we're going to have some questions from the audience regarding that. Where can we get this mentorship? Who do we even pick as a mentor? Because I believe a mentor helps to mold you to be the kind of arbitrator that you want to be, and probably make some referrals for you. So it's probably a question that will come up later in our discussions. So maybe you just want to note that down. Okay, so we're going to go quickly to a general questions for everybody. It's a 2-part question. I'll read it out. So in appointing or being appointed as an arbitrator, how do you evaluate expertise and qualifications for a particular case? Prof has already touched upon that a little bit in his experience in the Lagos Court of Arbitration. And the second part is, what process or guidelines do you typically adopt in selecting an arbitrator you want to appoint? So we'll start with the first one. How do you evaluate expertise and qualifications? And I'll put that to Mr. Bello first.
Thank you very much. And that's an apt one for me, coming from an in-house perspective. I have wondered that as a practicing practitioner, how do firms, or how do companies come to a peak of who they want? And getting in-house has opened me into how these things are, and they're not things we're not familiar with. The first thing is that I believe, like my CEO believes, that look, a serious law firm should have a website. You cannot, and because my CEO and my board are quite hands-on on the type of person who they will want to even arbitrate or even represent the organization in a dispute, they are quite hands-on to knowing, look, what kind of firm, what kind of person is leading, what we are doing. So things like soft things like, seeing the firm and personal profiles on the website, articles written, or cases done by the person or the firm, particularly with respect to things that may have touched on the type of disputes that we are trying to resolve or arbitrate. Those kind of things help a lot. Then referrals from practitioners, because as the head of legal or as a legal advisor in a fast-paced companies like this, the expectation is you have a social network around legal practitioners. From your experience coming from practice, you are able to identify those people who are sufficiently knowledgeable and have commercial acumen, not just having the technical legal knowledge of law generally, or in an aspect of the technical space where you operate, but you have a knack for commercial, manner of approaching issues that makes the company understand that you understand the business and the need to unknot issues in a manner that drives commercial solutions to problems. Of course, personal interactions with and feedback from colleagues generally also helps in synthesizing, the type of person you would like. So these are some of the soft issues. Then, of course, we things like who is who legal and legal directories, who's who legal, and all those type of directories that point to firms or personalities in the legal sector who have who have made their mark in arbitration and litigation, in international, dispute management generally, will usually give you pointers as somebody. So you are able to inform your board or advise your board from an informed perspective, that these are the kind of people I have shortlisted for your consideration and for you to let us deliberate, because my board will deliberate with you as head of legal to know why you're choosing this person as against this person. So those are some of the considerations. Thank you.
Thank you so much. Prof, in his previous question, actually touched a lot on this. So I will now ask Manish the same question. How do you evaluate expertise, qualifications for a particular case? And what guidelines do you typically adopt?
Thanks.
Because you wear two hats. You seem to wear two hats.
Let me perhaps address the question from my perspective as counsel.
Yes, please.
And also draw a distinction between appointing a co-arbitrator and then participating in the selection of the presiding arbitrator, because the considerations may be different. And just focusing on the co-arbitrator appointments, if you just look at a very basic level, and you look at some entry-level filters, then they'll give you someone competent. And these are filters such as familiarity with the governing law, relevant language skills, availability, subject matter expertise. But I think in international arbitration, we go much beyond those entry-level criteria. Because the real art now is to respect the principles of independence and impartiality while still identifying someone who, based on their background, what you know about their approach, is still more likely to be receptive to your case theory. And I think that is where the real strategy comes in. Because, for example, I may have a case that turns on interpreting a clause in light of its commercial purpose, not its literal language. And therefore, I may not want somebody who's going to take a very strict textual approach. I might want somebody who's open to contextual reasoning. And as specialist arbitration practitioners, we've seen a lot of individuals in action, whether as co-arbitrators, as counsel, tribunal members. So, you're trying to make an informed judgment about how a potential candidate is likely to reason. So it's a very thin line, right? So you obviously do not want to appoint somebody who's partisan. You want to respect the principles of independence and impartiality, but you want somebody who, based on what you know about them, will likely be predisposed to your client's case. And so that is really, quite key to the strategy of appointing a co-arbitrator appointment. Similarly, when it comes to the chair appointment, the dynamics tend to be quite different. Again, as all of you know, the chair is the most influential member of the tribunal. We have this unwritten convention in arbitration that it is the chair who drafts the procedural orders and the award, and they are also kind of responsible largely for the procedural conduct of the arbitration. So there you're not necessarily looking for someone who will align with your case theory, but you're looking for someone who can lead, who's intellectually strong, who's procedurally sound, and who will command the respect of both sides. And we often have this saying, which is kind of taken from kind of the court processes. In arbitration, it's just not about what's the law, but it's really about who's the chair. And therefore, as arbitration practitioners, you are exercising these judgments, picking up on the points that were made by my colleagues earlier. You really are kind of evaluating candidates in terms of your case theory, in terms of the kind of the other criteria we described, and that can really make or break your arbitration. I'll pause there.
Thank you so much, Manish. Thank you very much for that. So flowing from that, I'm just going to ask a simple question. And I'll put that to all the panelists. In one word, I mean, because we've spoken about appointments and we're all involved in some level of appointments of arbitrators. And there are many considerations taken together or isolated. But what is that one thing in one word that you're not willing to compromise or you can't waive when selecting an arbitrator? Just a word. What would you not compromise on? Prof, I'll start with you. Just one word.
Integrity.
Integrity. That's a good one. Very important. Mr. Bello, what would be yours?
Integrity.
Oh, wow. Okay. And Manish?
But I add to that, and I would echo that as well.
Okay. So it is integrity, integrity. It's
Exactly.
yes.
If you permit me, you see, at IHS, integrity is the core driver or core value of our business, and for us, it's embedded in virtually everything we do, such that if you're being appointed as a vendor, as a lawyer, as arbitrator, as anything you want to do for us, it is such that we must see that your ability to be trustworthy, to be respected amongst peers, and all these things. It's not, we can't compromise it for anything.
Okay, that's good to know. Yes, Manish, please.
I was going to say I couldn't agree more. And albeit our field has expanded, it's still a very small community, and our integrity and credibility is all we have in terms of capital, and that is why I know this is a kind of a debate we often have with clients as well, because there are unfortunately some who've acquired now a reputation for always ruling in favor of the party that had appointed them. And we often say to the clients that the best that can happen to you is if somebody like that is appointed by your opposing counsel or the opposing party. Because if you look at the dynamics of tribunal decision making, if you're obviously partisan, it's quite likely that you would then be marginalized on the tribunal, and your vote wouldn't carry any real weight with the chair in particular, and therefore one has to really be mindful about that. So it's quite important actually, and I that's why I fully endorse what has already been emphasized.
Oyelola, can I just quickly jump in as a follow-up to this point on this integrity point? Manish earlier on had sort of given us the nuances in terms of what you look at for the purposes of appointment, and he made the point about at an international level. You want somebody who has a predisposition to your case theory. I don't want our younger ones to take that to mean that when you appoint an arbitrator, you appoint an arbitrator to advance your case, which is totally different from what Manish is saying. Because I mean, in my life as an arbitrator, I've experienced situations where when people are trying to appoint me, they say, we want to appoint you as our arbitrator to advance our case. And then I just say, look, I'm not interested in that. If you want an independent and impartial person that would look at the case on the merits, then I'm your guy. But if you feel that I'm going in there to go and advance your case, then please count me out. So it's extremely important that we understand the nuance on this integrity point, which is very, very, very vital.
Thank you so much for that, sir. I'm glad you provided that additional clarification. So, believe it or not, we're fast running out of time. And we have a few questions that I think are very important for us to touch. So I will put that to the panel once again. What are some of the best practices? This is a little bit technical, but I think it's important in drafting arbitration clauses that relate to arbitrator appointment procedures. And I will start with you, Mr. Bello, because it usually starts in your office. You start with drafting drafting these clauses that that our arbitrators now have to wriggle themselves around and about. So what are some of the best practices in drafting these clauses?
Thank you. Honestly, you're right that it starts from our table house because we own the dispute.
Yes, it does.
You know, so first things first, from an in-house perspective, you get a team to do a research when you're going, and this research starts as earlier enough when the business is being consummated. You want to see the width of the possible disputes that could arise, and you want to benchmark those disputes against possibilities of what could happen if you word your arbitration clause in a particular manner. So you want to anticipate your own the possibilities that may arise, when the dispute starts. So the first thing is to understand your business. What kind of dispute will arise? Am I going to need a technical assessor or an arbitrator who is legally and commercially inclined? Do I want ad hoc, or do I want an institutional arbitration? What model of arbitration do I want? Do I want the LCI? Do I want the ICC? What rules do I want to govern? And these are the things that form the basis of how you're going to craft. And that is not to say that you will not call in people like Manish or like Prof, to even try to advise you when you've come to the conclusion of what you perceive might be what you want to word your arbitration. Like if it's an international, if it's a contract that has foreign elements, like a foreign contract or moving of, and like our business, which involves a lot of foreign elements, because most of our products which we use to do our business are imported. You will find out that you have a whole raft of international indices that will affect how you're going to relate with the dispute you're going to deal with at the end of the day. So I think from an in-house perspective, the first thing is to understand the business, the type of dispute that will emanate, the type of dispute that could emanate, and the type of outcomes you are looking at if those disputes arise. And those are benchmarks that form, and of course, professionals who are going to help in guiding you to ensuring. And I think from an in-house perspective, honestly, the drive of business is what is the possible outcome from what I'm putting on paper. And I'll just leave it there for those on the field to tell us more about how to go about this. Thank you.
Thank you very much. Manish, can we have your perspective on this? Do you have some insights?
Thanks so much. I think one issue that's often overlooked in drafting arbitration clauses is how the chair of the tribunal will be appointed. Because most clauses, including most model clauses that institutions specify, will talk about the seat, the number of arbitrators, the applicable rules if you're choosing institutional arbitration. But they don't often go further and give you guidance as to how the chair would be actually selected. What you have in most institutional rules are some default rules, which may either say that the chair will be selected by the two co-arbitrators, but without giving any specific guidance on how that selection would be made. Or the institutional rules may say that the chair will be appointed by the institution itself, but again, without giving any greater clarity on how that selection would be made. Now, in many cases, an institutional appointment or an appointment by the co-arbitrators without further processes may be fine. That may be sufficient. But I think what typically happens is where you have very high stakes, complex disputes, then parties in our experience often want more control over the process. And one option that we increasingly see is a post-dispute agreement between the parties, for example, on a strike and rank mechanism, where each side will rank candidates identified by either the co-arbitrators or the arbitral institution, and then the highest ranked candidate becomes a chair. And I think that process parties feel gives them some influence over the selection of the chair while maintaining the neutrality and balance that's quite important on the tribunals. Now, that consideration obviously has to be balanced against over-engineering appointment procedures at the contract stage, which is why most institutions don't kind of give you that level of detail, because you can, by kind of specifying too much at the very beginning, can also sometimes create unintended complexity, especially when the nature of the future disputes may not be that well known. So again, that's a balance that one has to strike, which is keeping your clause simple but complete in terms of the guidance that you have from arbitral institutions, but also just being alive to the fact that when the dispute does arise, you do have an option of agreeing as between the parties on the specific process that must be followed, particularly when it comes to appointing the chair, which can be a variation of processes. And there's a lot of institutional guidance now available on how one can go about that process. But it's something I find in practice it is not often given enough thought to. And as we were discussing earlier, that is the appointment of the chair is the consequential decisions you make it in arbitration. So it's just something to be alive to.
Okay, thank you so much, Manish, for that. And Prof, the final word on this question.
Okay, I'll just quickly say that, well, to the extent that I'm not in-house counsel, so I hardly draft these arbitration clauses. But I think Benga has touched on the most important point from the perspective of an in-house counsel, is that as in-house counsel, when you're drafting an arbitration agreement, you must be intentional and strategic. You must know where your company potentially stands in the event of a dispute resolution. And that would then sort of influence other things like the number of arbitrators, the specific qualifications that you might want to insist on in terms of the arbitrators. We're increasingly seeing in Nigerian context arbitrations where you have a panel of 3 that the agreement then says that the presiding arbitrator should be a non-Nigerian. At least I've been involved in like 2 of that. Just so that the question of independence and impartiality is brought to the fore. So those are the kind of things that in-house lawyers have to be very, very conscious of. There is the danger that one sees of in-house counsel just doing a cutting and paste job. They think that an arbitration agreement fits all, but absolutely not. You have to play with the agreements depending on the nature of the dispute that you envisage. And then in a Nigerian context, which is not particularly relevant in an international context, is also the issue of costs, because the way that you craft your arbitration agreement also has an impact on costs. In terms of whether you want a tribunal of 3 or a sole arbitrator. Again, depending on the complexity of the transaction that you're dealing with, that will then determine whether you're going for a sole arbitrator or a tribunal of 3 and stuff like that. So the question about ad hoc arbitration and institutional arbitration is just gaining ground in Nigeria domestically. But those are the kind of issues that in-house counsel have to be very, very intentional about, and not just feel that, oh, that arbitration agreement in contract A, we can apply it to contract B.
Okay. Thank you so much, Prof. But I'm not leaving you yet. This question is also for you. So, have the provisions of the new Arbitration Act in Nigeria made any significant improvements to the process of appointing arbitrators?
Absolutely, yes, Oyinlola. The new AMA has made some significant changes in the context of the appointment process of an arbitrator. I mean, the starting point is that the AMA still recognizes party autonomy in terms of nomination for and the procedure of appointment. So the parties still have the liberty of determining the timing, the credentials of the arbitrators, and whether it is going to be a tribunal of three or not. But where the AMA makes a significant impact is in the default appointment process, which introduces a lot of significant change. One is that we see a number of arbitration clauses where there is no time frame stipulated for the appointment of arbitrators. So that tends to even elongate the process, increases the room for arguments and disputes in terms of the time it takes to appoint an arbitrator. So under the new act, if you look at Section 7, where no time has been specified by the parties, then there's a 30-day limit for doing the appointments, or otherwise you then go on to the default appointment process. But I think the significant change that the AMA has made is in the fact that it has now expanded the default appointing authorities where the parties have not agreed one. You know that under the old law, you had to go to court to have the court appoint an arbitrator for you. Under the new act, they've now added the fact that you don't need to go to court. You can go to any arbitral institution in Nigeria to make that default appointment for you. And that is a very, very significant development because I recall a couple of years ago at the CIAP conference in Ibadan, one of the sessions had a retired judge, and the discussion was around his experiences on the bench. And he was talking about his experience of doing a Section 7 appointment under the old law. And that when he was going to make the decision about the appointment, just thought, oh, this is my old classmate who's not been doing much in law. I better appoint him. And he appointed him. We laughed about it, but deep down in my heart, I mean, I really felt that this is exactly what we don't want in the context of arbitration. So that possibility has been eliminated. Once upon a time, it was very fashionable to also have the CJ of the courts as being the appointing authorities in most contracts. And I've had opportunity to caution people in the past based on experience. Some of us might not be aware of that there's a popular case of Econet against Celtel, which was a popular arbitration in Nigeria at the time. At some point before the arbitration got off the ground, a notice of arbitration was given, and the default appointing authority was the CJ of the Federal High Court. And when the party invited the CJ to make the appointment of an arbitrator, the CJ refused, saying that that there was no dispute at the time. So in that sense, the CJ thought that it was a judicial decision being made in the context of appointment of a default arbitrator. So it took a while for the arbitration to get off the ground simply on that point alone. So I tend to caution that you have to be very careful in terms of the default appointing authority that you've chosen. I think if I'm going to make any comment about possible areas of concern with this new development in the AMA is the fact that it doesn't define an arbitral institution. It doesn't exactly give what it means. And then I pose the question that if there is an institution that has a mandate to encourage and engender mediation and not arbitration, is that institution an arbitral institution that you can go to appoint arbitrators? It is a thought that I'll leave with all of us. I don't have the answer to it, but the law, as much as possible, makes it clear that there should not be any issues about quibbling about who an arbitral institution is. So, I mean, if you decide that you want to use CIAB as the default appointing authority, somebody else cannot say no, but why don't you use LASIAC? Or why don't you use LCA? or whatever. You can't do that. Once the first party has moved in terms of engaging with that arbitral institution, then that is it. So these are the significant sort of developments. The mere fact that you don't have to go to court, you stand the risk of the extended period of trying to get that appointment, because you go by originating summons. It could take months, but you could get your appointment from an arbitral institution in 7 days or less. I mean, and that is a significant sort of quantum leap in the context of appointment of arbitrators.
Thank you so much, Prof, for that insight. And just like that, we've run out of time. But since I have the power of the mantle as a moderator today, I'm going to ask one last question and pose it to Manish. And that has been, you touched a little bit about it, but I would really like you to just speak about your experience serving as an arbitrator in different jurisdictions, just to give us an international insight on your experiences to help out our audience here.
Thanks so much. I think in my experience sitting as an arbitrator in different jurisdictions, what stands out is that while arbitration has become more harmonized, thanks to institutional rules, the IBA guidelines, best practices, I think there are still very meaningful procedural and cultural differences that one has to navigate. Because as an arbitrator, you're not just applying rules. I think our colleagues mentioned earlier, you're also managing user expectations. And just to give you some examples, in some jurisdictions, it's entirely normal for counsel to contact arbitrators pre-appointment and to interview them about availability or experience. Whilst in some other jurisdictions, that kind of contact is not usually considered appropriate. And again, as an appointee, I've had to be conscious of those norms and cross-jurisdictional differences, whilst at the same time ensuring that you're complying, with the institutional rules. I've also found in practice that there can be differences in terms of procedural assumptions. For example, in some settings, parties expect, and I think that's becoming the norm now, very detailed written submissions or memorials, with pleadings on law, fact, and pleadings that are accompanied by all of the fact and expert evidence on which you rely. But you have certain other jurisdictions in the world where pleadings are more limited, where evidence follows much later. What we often call kind of English court style pleadings. And again, as an arbitrator, the approach you have, the parties you have before you can really shape how you set timelines and structure the hearing. I've often also seen those differences play out at the hearing as well, because, in terms of, say, cross-examination, in many international settings, it's perfectly acceptable and, in fact, even strategic for a party not to cross-examine a witness. But in some countries, for example, that might well be construed as an acceptance of the testimony. So again, when you're sitting with co-arbitrators from different backgrounds, you have counsel appearing before you from different backgrounds, you need to ensure that you're communicating openly as a tribunal at the procedural stage as well, so that everyone has a shared understanding of what kind of procedure would be adopted. So again, I think those differences is what makes our field really fascinating and intellectually stimulating, but also are ones that can really affect user experience of the process. And that's why as an arbitrator, you have to be really alive to that. I'll give you one example and conclude there. There is this kind of convention in most arbitration practices to put all the filings on a Friday evening. But it's a very minor point, but I was sitting as an arbitrator in a case recently where we had parties from certain jurisdictions, and where one of the arbitrators said, well, actually, you know, putting a deadline on a Friday is not going to be appropriate because, there are constraints on availability, and it's an important day as well. And those kind of minor differences can actually be quite important, and that's where you really have to be culturally aware, uh, when you're dealing with parties from and arbitrators from different jurisdictions. I'll pause with that example.
Thank you so much, Manish, for that insight. So we're a little bit over our time for the questions for the panelists, 5 minutes. I'm quickly going to go through the poll right now before we go into the questions from the audience. And that would just give the panelists an insight of the kind of the array of people that we have. So the first question is, have you ever been involved in selecting an arbitrator for a case? We have more than 55%, that's about 56% of people that responded that they have never been involved. So I can imagine that the information provided at this forum will greatly enrich them. And then for those in the current professional roles, the selection, 68% of our participants today are legal firm practitioners. We have only about 1% that are arbitrators, and others have not responded, and only 18% that are in-house counsel. So a lot of practitioners out there. And for the audience, what do you think is the most important factor when appointing an arbitrator? Let's see. Integrity is not there. But quite a lot of people are concerned about independence and neutrality, which I think it's almost up there as well. And then subject matter expertise apparently is a very important factor to a lot of people in our audience. And track record and experience are also quite out there. It's ironic and it's interesting to note that there is no vote for diversity, that is gender, geography, or background. And that's quite interesting. And I would have loved to touch on that, but because of our time, I think Manish or Prof, you will take those questions down for our part 2 of this series when it comes up. And whether or not people have submitted their CVs, let me see that. Yes, to an arbitral institution, almost 74% have said no, they never have. So the process that Prof put forward for us, I think is very good and interesting and very enlightening. So people now have an idea that can be done, and maybe you should start with some of the advice that Prof has given us. And do you think diversity in arbitrator appointments has improved in recent years? 35% are not sure, and 28% believe it has. In-house counsels have been recommended or influenced the choice of arbitrators. Many of them, 60% of the audience, is not applicable to their roles. So I will stop there. That's halfway through the questions so that we can actually take some questions from the audience. I will try and run through as many as I can. For some of them, they've already been addressed. For instance, Shatima Mohammed, how do parties compel a party to an arbitration agreement to participate in an arbitration proceedings upon the appointment of an arbitrator by the court? It's a tongue twister, that one. So how do you compel a party to an arbitration agreement to participate in an arbitration proceeding upon appointment of an arbitrator by the court? Prof, can you help us with that?
Well, thank you very much for that question. The simple answer to that question is that you can't compel a party to participate in an arbitral process. But what you then have to do is ensure that as you move along in that process, you continue to notify that party of all the procedural steps that are being taken in that process, so that you, as much as possible, reduce, if not eliminate, any potential challenges to the award at the back end. But you can't really compel a party to participate, even if the arbitrator was appointed by a court. I mean, there will be no issues around you being in contempt of court or whatever.
Exactly.
that sense, you know.
Thank you so much, Prof, for that. Husseini Sani asked a question. I'm just going to read it out so that they know that we actually took it. But I believe if you listen to the earlier recordings and the presentation by Manish, you will find that this question has already been answered. And the question was actually for Manish. And it says, considering the increasing preference for arbitration over litigation, how can young and less experienced lawyers position themselves to build a successful arbitration practice, especially in jurisdictions where arbitration is still developing? So, Husseini, please listen to the earlier portion of this webinar. Manish really addressed that question. And there's another question directed to Prof. It says, in what situations would you advise against arbitration despite its advantages over litigation?
That is an extremely, extremely good question. And it is a question that, you know, has been on my mind for a very long time. And the way that I've put it to in-house counsel is that in as much as all of us are striving to put arbitration on the front burner, I say to in-house counsel that the truth be told, it is not all disputes that are well suited for arbitration. Again, as part of what Benga said, in terms of looking at the nature of the contracts and the complexity of the dispute, there are some disputes that are not suited for arbitration. So for example, I see simple landlord and tenant situations, and people are putting arbitration clauses just because everybody has gotten on the bandwagon of arbitration. As in-house counsel, if my company is involved in a simple supply contract, you know, that I know that all that my company has to do is to have paid for the goods, and then it is for that other side to perform the contract. There's no complexity in there. Why would I put an arbitration clause relative to a contract that involves not only the supply but the commissioning and testing? Then that's a different consideration. So in-house counsel have to be strategic. It's not every simple contractual situation that you find yourself that you must be putting an arbitration agreement. So that would be my own admonition to in-house counsel, that in as much as we really want disputes to be settled alternatively, but it's not all the time that arbitration might be well suited for particular disputes. I see simple loan agreements as well, simple facility letters from banks, and they're putting arbitration agreements. You're just creating an additional layer of cost and expense that perhaps will not bring you any value add in the grand scheme of things.
Thank you so much, sir, for that. I would have loved to get Manish's input, but I have so many questions to run through. Mr. Bello, this is for you. All the speakers mentioned integrity. This is from Jane Esemuze. All the speakers mentioned integrity. Is it measurable or based on perception? And whose perception subsists?
Fantastic question. And honestly, it's a trick one. What's the point integrity? It could be measurable because, as Manish said, the legal circle is quite small at the end of the day. And there's a level of respect with which people look at practitioners to know this is the type of person I want to appoint. Can I talk to him in a manner that he understands me, not necessarily compromise himself for my case? I tell you what, Prof is doing a case for my organization, and the first thing I had to ask him was to do an opinion, and I challenged some of the points he had made in the opinion, and he was resolute about the question, about the answers he provided. He understood that, look, he needed to manage because there was a certain expectation I had, and when those expectations were not being met from his answers, I thought, oh, I have given an indication to my board that it is likely this will happen. So I had to recalibrate my strategy, you know, and make it. And that is somebody who I respect so much because I know that, look, Benga, the ideal thing will for me to make you happy But I'm sorry, I can't make you happy because this is the situation of the factual circumstances of your case. So you will also find that in IHS, for example, we have this sifting process that we can put names of professionals in a pool. It's an AI generated stuff. All it does is it goes into the news and generates news about those who we fed into the system. And it starts to tell you certain things that they have done that may be tricky for you to opponents. What kind of things have they done in projecting themselves? Like somebody who has got in a fisticuff as a professional, in trying to drive certain things. You don't want to, engage that kind of person. So it's tricky, but then there are some measurable manner in which you can see through how much of integrity professionals have when you want to appoint them. Thank you.
Thank you very much. That's really great. Ehinomen OJ asked a question. I would also refer you to the earlier parts of the webinar. And it was, how can a lawyer practically become a practicing arbitrator? Where do they position themselves? Do they join an association? Does someone in a big company have to be recommend them? Or do they just learn and get certificates on arbitration and don't practice it? I think Prof really touched on this, and Manish as well. We don't want to overqualify or over-certify ourselves without having the substance. There's another question from Sonny Etia, an in-house counsel in an FMG in Lagos. In an era where disputants increasingly gravitate towards more flexible ADR mechanisms, what deliberate steps can arbitrators take not only to demystify the process, but also build genuine trust and confidence, especially when the formality of arbitration risks alienating everyday parties? Manish, can I throw that to you?
Thanks so much. I think that's a very important because as arbitration becomes more formalized, there's a risk that you can lose touch with the very values that made it attractive in the first place, right? Accessibility and flexibility and party autonomy. I think in terms of deliberate steps that the arbitrators can take to build trust, I would highlight three. One is the point I made earlier, which is clarity in communication. At the procedural stage, kind of explaining very clearly the timelines, a willingness to engage with the parties, particularly those which are unfamiliar with the process. So you're not kind of, turning this into an intimidating process. And that can be quite important where you have parties with kind of different levels of experience with the process. The second point I would note is about active procedural management. Because in my experience, one can really lose faith in the process when the process drifts. And therefore, as a tribunal, you have to be quite responsive, and you have to be visibly invested in the progress of the case. And that can go a long way in engendering confidence, even when the outcome isn't favorable. So, if you look at most surveys of users, one complaint that you often hear about is the time it's taking now for arbitral tribunals to render their decisions after the final hearing. And I think that adds a lot to kind of the alienation as well. And I think that's where one has to really be very focused in only accepting arbitral appointments where you can give a case the love and attention it deserves. And finally, I would say the tone and conduct during an arbitration can be quite important, right? It's about how you speak to the witnesses, how you listen to the parties. Are you able to create this atmosphere where people feel that their voices have been heard and they're being treated fairly? And that's not always driven by legal rigor, right? It's also driven by human signals in the way you're interacting. with colleagues. So I think those are some of my kind of reactions to kind of guarding against that alienation that's being raised in the question.
Thank you very much for that. Love Ugeberio asked, I'm sorry for the pronunciation, asked a question, but I'll tweak it a little bit. And it's really about how effective has been the introduction of technology into the arbitration practice. And I would take it down a notch into the selection, the process of appointment, and even when you're working now as an arbitrator, how has technology played any significant role? Prof, can you help us with that? And then I'll go over to Manish.
Oyinlola, this is a difficult question for me because I'm not a tech savvy person. I'm still a dinosaur in terms of exploiting the extent to which AI can assist arbitration. To be honest, I mean, I know that there are a lot of stuff out there, and then there are also the ethical issues around the use of AI. I'm studying everything carefully. But to be honest, I've not really jumped into that arena to be able to make any meaningful contribution to the question. So I think I will turn it over to Manish or Gbenga. I mean, Gbenga made a very interesting point of how they use AI to even
Use AI. I noticed
AI.
when he mentioned that to
I
just
was
make a
intrigued.
selection of,
Exactly. I was
my
intrigued.
eyes were open, like, okay.
I was intrigued. And I was going to ask him privately that, Gbenga, have you ever dropped my name into the pot to to have it checked?
To the pot and see what came up.
Yes.
Trust me,
Well, that
fantastic point. Fantastic point, Prof. Human disputes concerning humans are hardly things you can start visualizing how you do it with a rubber stamp like AI, even though AI has gone through its own process of coming to where it is right now. But then it offers some help in appointments and all that. So when I say we threw names in AI, we just probably put it in some security search engine, that digs up security searches of people, and that's AI for me. I'm as I'm as a I'm as a I'm as a dinosaur as you are, Prof.
my goodness. So, Manish, will you bail us out from this group of dinosaurs?
I think one thing I would say is the technology is changing and evolving so quickly that my own
Mhm.
views on this have evolved considerably over the last 1 year. I don't want to be a doomsayer, but I think our field has already drastically transformed in the last 1 year, particularly once generative AI became part of the mainstream. And I think we'll all have to adopt it, and we'll all have to adapt very quickly. Just on your specific question, I think from an arbitrator's perspective, how does one use AI? I think the guidelines on that, obviously, it's quite important that you don't delegate decision making to any tool or anybody else. But I think there is now a growing recognition that some of the kind of the more manual tasks, creating summaries, procedural histories, tasks that were traditionally kind of assigned to tribunal secretaries, may be outsourced. And I think that is something we'll obviously have to kind of continue to observe. I think as counsel, there are such sophisticated tools now available that I think the landscape's completely changed. We as a firm have always been kind of quite nimble and adopted kind of technological innovations quite early on. But quite recently I was even kind of doing a pilot for a tool which kind of creates a sandbox, so no confidential data is shared outside of your organization. But you're doing live hearings, doing cross examinations. It can kind of monitor the evidence that's being given, identify inconsistencies, suggest follow-up questions, and you can see those kind of technologies now kind of becoming increasingly part of the mainstream. And it will raise a whole host of issues, of course, for tribunals in terms of the procedural directions, the transparency around use of AI by parties and arbitrators. But I think the upshot from my perspective is that it's something all of us would have to really grapple with and grapple with pretty quickly, because it's there now, and and more sophisticated, even in-house counsel we are working with are relying quite heavily on that. So I see this as completely altering the way we are practicing in whatever role we have.
Thank you, Manish. And I will make sure that I move out of this dinosaur club myself. Okay, I think we've spent quite a lot of our time, even trying to take as many questions from the audience. I have two more questions, but they're more like comments, and I would like you to end your notes on those two questions, preferably either one. So, Dienye Fubara made a comment saying, is it not time for the Institute, or I think generally, to champion the inclusion of arbitration as a course to be studied by law students at the undergraduate and law school level, seeing it is a useful means of conflict resolution? That's one question. And the second one is, maybe this is not a question, but a comment. Parties will quickly agree to arbitration and then make a U-turn when the award does not favor one side, and then subject the award to litigation. So we can have your closing comments on either one do you prefer, whether we should, or both, whether we should include it in the curriculum and champion it, and your thoughts on the fact that after the award is given, parties just run back to litigation. So we can start with you, Mr. Bello, and we can go from there. Closing thoughts.
The second issue resonates more for me in terms of its the fact that it's one of the things which makes arbitration a bit tricky for people to consider in view of the litigious nature people have tried to bring into it. And I think this is where I think our judiciary has to put its foot down. That look, once you choose by way of an agreement that this is the path with which I want my dispute to be resolved, you shouldn't. One, it's the law that you sink and swim with your arbitrator in terms of errors that the arbitrator make. You saw him and you chose him like that. So don't come back to us except the basis upon which you're coming to us falls within that limited scope. And I think that is where our judiciary has got to put its foot down and make arbitration the real bride that it is. It's a function, it's something we need to keep driving with the policymakers, the judiciary, to please let arbitration be arbitration that it is. Thank you.
Thank you so much for that insight. Prof?
Thank you very much for the question. And I think, look, the question resonates with me both as an academic and also as a practitioner. In terms of being an academic, I totally agree with the comment that ADR and arbitration in particular should be added to the curriculum. So in Unilag, for example, even though we don't have it yet on the curriculum, we're working towards it. But we have an ADR society, and those kids are doing wonders. I mean, Manish talked about the Vismuts. Our kids go to Vienna every year. They go to Kenya also every year. We try our best to assist them with funding. So those kids are quite knowledgeable independently without having it on the curriculum. So I agree that if we have it on the curriculum, it changes the landscape entirely. And then on the last point, I mean, Benga has pretty much touched on it. Historically, we say in Nigeria that arbitration is just simply a first step to litigation. And we really need to change the direction of travel. And it is our hope. One of the things that the AMA has done is that it has rejigged and recalibrated the grounds for trying to set aside an arbitral award. We had this nebulous concept of error of law on the face of the award, and people had used that as a backdoor way of appealing the merits of an award. That has been taken out in the new act. And the expectation is that the courts will now be a lot more circumspect in considering the extremely limited grounds upon which you can seek to set aside an award. And we're hoping that the jurisprudence will change and by extension engender arbitration. We need an attitudinal change. You know, the idea that you are unhappy with the decision and you must take it someplace else to challenge it. We must bring it to a stop, you know. And like Benga said, you've chosen arbitration. You sink or swim with your arbitrators and the decision that they've rendered, you know, with exceptional situations which are clearly stated in the law that relate to corruption and going beyond jurisdiction. Those are clear points. But aside from that, you can't start quibbling with the reasoning, their findings and stuff like that. Okay, thank you.
Thank you so much, Prof. Manish, the last word from you.
I think I'll find it difficult to kind of contribute to what my colleagues have said. I think I really endorse everything they've said. I think as a trend, I will note that the rate of voluntary compliance across the globe is actually declining, because when we started our careers, one of the virtues of arbitration that one used to highlight was greater enforceability and particularly the higher rate of voluntary compliance. But a lot of my work involves states and state-owned entities across the globe, and that is where I think we are seeing a shift, which is to kind of exhaust all possible avenues before an award is complied with. So that I just make that observation by way of a trend. But again, in terms of solutions, I fully agree with what my colleagues have said.
Thank you so much, Manish. Thank you to our very distinguished panelists for your time and wealth of knowledge. I believe we've all gained so much. And for listening to me. I'd like to call upon the chair of the in-house counsel committee, that's Dr. Esson, for her closing remarks. I believe she's online.
Okay, thank you very much, everybody. It's a pleasure to be here. Can you hear me?
We can. Yes, we can.
I can't hear much. Okay.
Can you hear us? Okay.
Yes, I can hear you now. I could not initially. So I want to say thank you so much for, participating in this webinar. It's been an interesting and insightful session for me particularly. As in-house counsel, I have now learned more. I need to be strategic and intentional. And if I want an appointment, as an arbitrator, I need to be known according to Manish. So as this session concludes, I'll say thank you everybody for participating. I also want to especially thank our esteemed speakers, Manish, for your practical, insightful contributions and your guidance, on different aspects of the topic. Professor Olawoyin, thank you for sharing your profound knowledge as an arbitrator, as a counsel, and as a professor. And to Benga Bello, your observations, contributions, they've provided very comprehensive view of the subject. And for this, we are very grateful. So from all of us at the corporate and in-house counsel committee, we will be looking on to calling you for some of other sessions. We are going to be having this webinar on a monthly basis. And of course, I must thank the moderator, who is one of us. She's a member of the Corporate and In-house Council, Mrs. Oyinlola Adebayo, and she's the Company Secretary of AMCON, and also the webinar coordinator, Mrs. Iretioluwa Banjo. She's also one of us, a member of the committee. Thank you for all the work you have done in putting this together. And to all our participants, please watch out for many more series, webinar series on different aspects of arbitration, mediation, ADR, particularly those that touch on our pain points as corporate and in-house counsel. So without much ado, our time is fast spent. I'm just going to call on the branch chair, Mrs. Olushola Adegbomire, to say a few words of thanks and, just to wrap up this session. Thank you very much, everybody.
Thank you very much. Just in a minute, I'll say thank you to all our panelists. You've done great. I will just be repeating what Dr. Eson has said, but I thank you for really sharing of yourselves. I like it, you're all being real. Thank you to our moderator, to our coordinator, to the in-house counsel committee led by Dr. Eson, and to all those who have attended. We have about close to 1,000 people. Some are on the Zoom platform, some are on YouTube, and it's beautiful to see that people are really engaging. There's still some questions that have come towards the end, but we can't just keep going on. We're already about 3 minutes, about 4 minutes gone over the time. So if you have other questions, I think you can send them to our website. Just go to our website, and if you send us an email, we'll answer the questions. I see people are asking how they can become members of the Chartered Institute of Arbitrators. If you go to our website, the telephone number is there. You can call us, you can send us an email. We'll definitely get back to you. The link for CPD points have also been put there. So you can go to the link and fill in the form for CPD points. And thank you very much. Thanks to the in-house and corporate counsel committee. Thanks for, Manish is not coming in from India. I think you're coming in from London. I was going to say we are asleep now, but thank you to everybody. And we look forward to seeing you again. Thank you to all the participants. I know you've all learned something. I have learned something from all the speakers. I have definitely learned. I hope I'll be getting more briefs using all the tips and tricks that I have learned. I'm looking forward to getting more arbitration appointments as well. So thank you very much. We look forward to seeing you next time. Do have a wonderful afternoon. Today is Tuesday. The week is just starting. Have a winning week. Bye. Thank you.
Thanks.
Thank you. Thank you.
Very much,
Bye.
everybody. Thank you.
Thank you. Thank you.